Alex and say hello. So Alex, he may be familiar to many of you. He's spoken at quite a few Scribe Academy events in the past. He's also spoke at Scribe Fest. He's a key partner, well, he's a partner at and on the commercial team, corporate and commercial team at Leathes Prior. And he's pretty much involved in acquisitions and mergers and acquisitions, but he's also into data protection, compliance, etc. So hello, Alex, how are you doing?
Hi there, John. I'm very well, thank you. Delighted to be here, albeit feeling slightly overdressed in comparison to your pink t-shirt.
Yeah, my pink t-shirt and the cap. Yeah. But you've got to look smart, haven't you? And your backdrop is awesome, isn't it? Have you read all those books?
Yeah, I was actually going to mention that this is a genuine backdrop. Obviously, the sort of the Zoom backdrops are becoming increasingly realistic, and I've often been caught out. This is a genuine backdrop. I'm in our boardroom in rather sunny Norwich at the moment. However, it's a grade 2 listed building, doesn't have any air conditioning, and I suspect the jacket might need to come off at some point. And in terms of your question as to whether or not I've read all of these books, it perhaps won't surprise you that I haven't read the 1956 All England Law Report into Land, but they look quite good, I think.
Yeah, they look cool. And also, I've been in that boardroom. It's actually overlooking Norwich Cathedral. It is pretty awesome room there. Yeah, you're lucky to have such an awesome working space. Anyway, tell me something that most people don't know about you. Surprise me. Because all this boring, lawyer, tell me something a bit more exciting.
Well, that's somewhat unexpected, John, and yeah, slightly intrusive question, I have to say, for a Friday morning, but there we go. Something that no one knows about you. Okay. So my grandfather used to, in the early 50s, drive what was then Grand Prix. So he was a Grand Prix driver in the early 50s. So not many people know that about me. I think it's quite cool. I kind of wanted the opportunity to be able to humble brag about that at some point. So I thought, what better time than now?
That's perfect. Oh, I'm glad we gave you the platform to do that in front of all these 110 clerks around UK. Anyway, enough banter. Let's get on with it. So feel free to share your screen. You said your mouse was a little bit dodgy, but yeah, get your screen share and jump straight into your talk.
Okay, thank you, John. Let me see, as you say.
There we
Can
go.
you see that okay?
Yeah, that's perfect. Over to you, Alex.
Great. Excellent. Well, morning, everyone. As John's glowing introduction suggests, I'm a partner at a firm of solicitors called Leathes Prior in sunny Norwich. And I specialise in corporate, commercial and data protection law, certainly data protection law for my sins. I've had the pleasure now of speaking at Scribe events. I think it was my 4th Scribe event, which is fantastic, and I'm absolutely delighted to be here. It either means I'm doing something right, or what I suspect is more likely to be the case. John can't find anyone else who's willing to give up their time. So delighted to be back with you all. So today we're going to take a slightly different approach to some of the previous events that I've talked at. So previously, and for those of you who've been at those events, on those webinars, I've talked about sort of data protection, Freedom of Information Act requests, and kind of what the law is and what some of the theoretical stuff is. What we're going to do today is take a really, really practical approach towards data protection and other kind of legal compliance. So this is going to be a really practical session, which is talking ultimately about what documents I recommend that you have in place in order to make sure that you've got proper legal compliance and to protect your organisation as much as possible. And that's really the aim of the game. That's the crux of it today, to try and protect your organisations as much as possible, whether that's from, regulatory fines, whether that's from complaints from residents or whatever. So that's the approach we're going to take today. And we're going to focus on 5 key documents that I strongly recommend that you have in place. And as the poll suggested earlier, it's great to see that most of you have at least some of those documents in place. But it may well be that either those documents can be improved or in fact that you want to implement additional documents as well. So let's get cracking, because we've got a fair bit to get through over the sort of next 45 minutes or so. So the 5 key documents I'm going to talk about: data protection policy, website privacy policy, data retention policy. So those 3 are really kind of data protection focused documents. I'm also going to talk about website terms and conditions and hire agreements, the latter 2 of which are more sort of commercial contract documents, but nonetheless very important to try and fend away any sort of complaints or claims that you might have. So as John's mentioned, it's a really important point to make. I'm by no means saying that these are all of the documents that your organisation needs to have in place. And you're going to have health and safety documents, employment documents, but these are the sort of the sort of commercial and data protection documents that I'm going to recommend you have in place to ensure legal compliance. And I'm not only going to talk about what they are and what to include in them, but why they're important and what the consequences of not having them could be. So, UK GDPR, our old friend. For those of you not familiar, and I suspect you all will be, UK GDPR is just the UK version of the EU GDPR, which was the new piece of data protection legislation that came into force in May 2018. So whilst I'm not going to be focusing on the sort of the theory and the law as much in this session, because we've talked about it a lot in the past, it's just worth a quick recap on when UK GDPR applies, and therefore when you need these data protection documents in place. So ultimately, the UK GDPR, in really, really simple terms, applies when an organisation uses personal data. So where you've got personal data that's being used, the GDPR comes into focus, and it's something you need to bear in mind. So in terms of what those 2 phrases, use and personal data, mean for the purposes of the GDPR, I just want to quickly recap on that because it's pretty fundamental. So firstly, personal data. So personal data is any information that identifies a living individual. Okay, a living individual. I say living, and I certainly don't want to sort of bring morbidity into this nice sunny Friday morning. But if you are, for example, administering cemeteries or graveyards, and you have records of those who have deceased, that isn't personal data. So it's only for these purposes, it's only data of those who are living, and includes a really, really broad range of things. So it can include a name, address, email address, telephone number, all the way through to an IP address. It can include more sensitive information about someone's health. It might include things like their job title or their employment history. You name it, if it identifies that person, then it's personal data. Likewise, use is equally as broadly defined. So using personal data, or the terminology that's used in the legislation, which is, you might have seen, processing personal data, is effectively doing anything with that information. So whether that's initially collecting it, handling it, processing it, transferring it to someone else, or being transferred it from someone else, or storing that information, even the right to access information can be considered a use of that personal data. And therefore, if you're doing anything with personal data, the UK GDPR applies, and you need to be thinking about the next 3 documents that we are going to be talking about, as well as just general compliance. So let's get stuck into the first document, which is really the main one. It sounds like the one that most of you already have. I think it was 93% on the poll, which is great. So hopefully this is going to be more just finessing that if needed, and it might be, hopefully gives you confidence that actually you've got everything you need in place on that front, and we don't need to worry any more about it. The data protection policy is, as it says there on the screen, policy document which sets out an organisation's code of conduct for using personal information. This is the most important of the data protection documents, and the one that if you're in that 7% who don't have it according to the poll, then I would strongly recommend that this is your priority in terms of putting it in place. So a couple of quick notes on data protection policy then. So it's an internal document. So, and I'll talk about this in a moment, but this is not to be confused with kind of privacy notices, website privacy policies, or employee privacy notices, which are external facing documents. This is an internal code of conduct for how your organization uses and collects personal information. So it's an internal document, shouldn't be shared outside of your organization unless there's exceptional circumstances to do so. It's intended for councillors, council staff, any consultants, if you have any agency staff or any volunteers. It will apply to all of those who in their day-to-day jobs will at some point collect and use personal data, which is most likely to be is going to be the vast range of people within the council. Importantly, and this is a really crucial point, it shouldn't form part of an employment contract. If you have a data protection policy in place, I would recommend that you include a line that says this does not form part of your employment contracts. And the reason being is because there's specific rules that apply to amending an employment contract. You don't want to go through that if you just want to update your data protection policy. So you should be able to freely change and vary that as and when you need to. And it also focuses on all categories of personal information. So it isn't category specific. It's not something that's just for employee data or constituent data or candidate data. It applies to everything. So it takes a holistic view. So you may be saying, well, that's all well and good, Alex, but what does, why do we actually need it? So the UK GDPR before that, back in 2018, significantly changed the goalposts in what organisations were expected to do in terms of data protection compliance. And we're 5 years on now, and a lot's happened in the meantime. But if you cast your minds back, GDPR was, there was some real uproar about it, and part of the reason was for the principle that's on screen. So the big shift from the previous legislation to the GDPR was they introduced this concept of accountability, which is that the organisation who's using information is responsible to show how they are complying with data protection law. And what that means is that organisations, here councils, need to actually show, they need to actually be able to evidence what they're doing to comply with the GDPR. Previously, it was fine to kind of be able to say, well, we are complying with it, and therefore that's the end of the conversation. As I say, the goalpost moves quite significantly, and now it's not going to be possible to comply with the GDPR unless you've got the documentation, the policies, the things we're going to be talking about to back that up. So it introduces this concept of accountability, which is one of the more onerous obligations under the GDPR. So what does that mean in practice? Well, probably will come as no great surprise. That means implementing your policies to ensure compliance, then reviewing, addressing those deficiencies, and then avoiding fines or any other consequences. So ultimately, the point here is, the takeaway point is, if you don't have those policies to back up the compliance that you're carrying out, you actually won't be complying with the GDPR, which has put quite a lot of onus on organisations, big and small. And it's worth remembering that the GDPR applies to all organisations. And there's no sort of turnover, or there's no kind of financial threshold that they need to pass for this to apply. So it's put quite a lot of burden on organisations from a compliance perspective. Just a quick note, and I'm not one of these lawyers that likes to scaremonger, because I don't think it necessarily gets you anywhere. But just to give you a bit of a practical example of a consequence of not complying with this concept of accountability, and with the data protection legislation more generally. So City of Stoke-on-Trent Council, an individual sent some documents in a child protection case to the wrong person. those were not password protected, they weren't encrypted, they were just on an email that went into the hands of the wrong person. The council got fined £120,000, and part of the reason for that is because they didn't have sufficient policies and sufficient documentation to be able to guard against and set out what the standards of data use are within the organisation. And I suppose that is ultimately the biggest point here, which is that if you have your data protection policies in place, you protect the organisation. And if someone then ignores those, it becomes a them problem rather than a you problem. If you don't have those policies in place to start with, then the regulator in the sector, the Information Commissioner's Office, will consider it to be a you problem, to be an organisational problem. So get your policies in place, get that sorted, and protect the organisation from rogue actions of individuals, whether deliberate or otherwise. And I think in this case it wasn't a sort of a deliberate malicious act, but nonetheless resulted in a fine. It's worth mentioning that, and you may well be aware of this, the fining powers under the GDPR increased significantly. There's sort of two tiers, 8.7 million for the lesser tier, and then up to 17.5 million for the greater tier, which is the sort of the more severe breaches of GDPR. However, it's very unlikely. The ICO have not been dishing out those kinds of fines left, right, and centre, and the levels of fine. The regularity of the fines have increased slightly since the GDPR came into place, but the levels of fines haven't increased significantly. So fines are very much a last resort for the ICO. Okay, so let's talk then briefly about what goes into a data protection policy and make sure that those of you who have this document in place have covered off all of the things you need. So the first thing, the most obvious thing that should go into a data protection policy is to set out each of the data protection principles, each of the 7 data protection principles. Now, I'm not going to go into any one of these in any great detail. I've done that on previous talks. Most of them are sort of similar to the previous legislation, but as I say, there's a couple of things that have changed, and the data protection policy should set those out. Most importantly, then, the data protection policy should set out how you are complying with them and what practical steps you are taking to comply with each of those principles. And that is really the sort of the crucial point in and amongst this, which is if you just set out and say, these are the principles that we promise we're going to comply with, the ICO will look at it if there is ever an investigation and say, well, that's fine, but you need to tell us how. And that's how you that's how you meet that threshold of accountability. So to give you a few examples, so data minimization is legal jargon for don't collect data that you don't need to. Only collect what you actually need to in order to do the thing that you want to do. So the practical step there in the data protection policy might be guidance for employees to say simply that, don't collect any more information that you need to, don't ask any more questions than you need to, review perhaps application forms. You know, are you asking things that really you don't actually need to ask in order to be able to do the thing that you need to do with that application form or whatever it may be. Likewise, accuracy, to make sure all of the information that you're storing is accurate. It might be a policy of once every year, 2 years, you just have a bit of a data cleanse, and perhaps you send an email around saying, you know, are these still your details? You know, perhaps you do that internally to make sure that you're checking that. Storage limitation, which I'll talk about in a moment, is all around how long you're storing personal data for. And as I say, we'll talk about that in more detail a bit later on. Integrity and confidentiality is about what security measures you've got in place. And this is probably one of the areas where you want to be putting in the most practical examples. So this is going to be things like saying, well, do we have any access controls for specific types of information? You know, do we have permission levels? So only those people who actually need to see the information can see the information. It might be things like, do we password protect or encrypt sensitive documents when we send out? In the Stoke-on-Trent city council example, it was because those documents hadn't been protected in the way that they should have been, and that security wasn't properly applied. What's the kind of practical measure to be able to deal against that? It's probably password protecting and encrypting if possible. You might have things, simple things like, you know, having employees change their password details within certain intervals. So there's all sorts of different things that you can add there, but the key is there to add the practical steps in, and then the accountability point is to refer to the other documents that you've got in place. You know, how are you meeting that accountability? Well, we're meeting it by having a data protection policy in place, having our website privacy policy in place, having our data retention policy in place. So that is ultimately the crux of a data protection policy. That's what it should set out. Ideally, you would have a category for each, and then you have what the principle is, and then how do you meet it? What's the principle? How do you meet it? And sort of follow that kind of structure. There's a few other practical points. It should be appropriate to the size of the organisation. You know, a small parish council isn't expected to have the same level of policy as perhaps a large city council. It needs to be easy to understand. That third bullet point on the right-hand side is really important, possible to implement. The ICO will take a perhaps an even dimmer view if you've got a policy in place that you can't actually comply with or you're not compliant with. So make sure that those things that you include in your data protection policy you can actually comply with, because if you've got a policy that you don't comply with, it's going to give you absolutely no protection whatsoever. We talked about the practical steps, and I'd recommend that there's also a section that talks about how regularly it's reviewed. I'd suggest sort of an annual review to make sure that it still suits the needs of your organisation. So that's data protection policy. So that's one of the crucial documents, but fortunately one that it sounds like most of you have in place. So the next one I'm going to talk about is the website privacy policy. So website privacy policy is a notice that would be on your website to website users and others to set out how, when and why the organisation uses personal information. So this is the opposite in many ways of data protection policy. Often those two things are kind of conflated and confused, but actually this is the opposite. This is the external facing document that says to individuals that you collect information from, this is what we do with it. And it's all around this idea of being transparent with people. So as I say, it's an external document. It should set out how you collect and use the data, so what sources you collect it from, and I'll talk more about that in a moment, and also why. It should set out the lawful basis for each of the sort of activities that you do with that personal information, linking it back to those lawful bases that I've talked to some of you about in previous sessions. And it should also touch upon data retention and link in with your data retention policy, which we'll talk about in a moment. So this is really the reason that you need a website privacy policy is for transparency, so that individuals that provide information to you know how it's being used. It's to inform those individuals, and I'll talk about that in a bit more detail. It's intended to give individuals more control over how their information is used, and obviously that idea that they'll have knowledge of it, and to strike a balance between the needs of the organisation and the rights of the individuals who are giving up their information. So that's sort of just a very brief overview. But really the importance and the reason that you need one of these is because of Article 12 of the UK GDPR, which is this concept of the right to be informed. So certain information needs to be provided to individuals when you collect their information. That applies right across the board. And the easiest way to do this, and the most sort of strategic way to do this, is to have a website privacy policy that sort of covers all of these things off. So there is a legal requirement to have one of these in place. And if you don't have one of these in place, then I would strongly recommend that you do so. So it's this concept of showing that you're taking privacy seriously, ensuring that individuals have confidence in you, and to protect, most importantly from your perspective, protect against liability, both from claims from individuals or complaints, but also non-compliance under the GDPR. But ultimately, what we're doing here is we are satisfying this right for individuals to be informed through a privacy policy, rather than doing it on an individual basis and providing individuals with that information each and every time you collect data from them, put it on your website, and then it will cover off everything. So let's get into the crux of what might be in the website privacy policy. So firstly, pretty simply, you need council's contact details. And on that point, and I'm not going to talk about sort of data protection officers in great detail today, because again, I've talked about that previously. But you would normally put the details of your data protection officer if you have one. Most public authorities need one, but crucially, one take home on this point is if you're a parish council, you don't actually need a data protection officer, and that's hardwired into the legislation. There's a lot of confusion around that point, and I did a sort of quick straw poll of parish council websites, and still a lot of them refer to data protection officers. You don't actually need one, and it's a formal role that carries additional responsibility. So if you don't need one, my view would be, unless there's a compelling reason otherwise, you don't need to have one. For those town, borough, county, city council, you will need a data protection officer because you're a public authority that isn't a parish council. So you normally include the contact details there. And if you don't need a data protection officer, then I suggest having sort of a data compliance manager as someone whose details you can put forward. You would set out the types of personal data collected. So you're collecting names, addresses, email addresses. Are you collecting payment information? Are you collecting transaction history? All of those sorts of things should be set out fairly early on in the website privacy policy. The website privacy policy should also set out where the data is collected from. Are you getting that from individuals directly? Are you getting that from third-party sources? Are you getting it online? You should set out what the potential sources of that data collection is. Most importantly, you should set out what's the purpose for that collection. Why are you actually using it? Are you using it, for example, because you need to use it to deliver a service? Are you using it because you want to have it, because you want to, for example, improve a service, you want to provide training or something along those lines? It should be clearly set out all of the different purposes that you'll use personal data or that you're collecting within the organisation. The lawful basis for processing is normally set out in a website privacy policy. So, for example, if you're collecting information because you need to provide a service, then you are probably collecting it because you need to comply with some kind of legal obligation or because you have a contract with that person. So that would be the lawful basis. As I say, unfortunately, I can't touch upon this we're just not going to have enough time to talk about this in too much detail. But that's going to be something that you want to include. Who's the data shared with? So there would normally be a section that says, we share personal data with these people for these reasons. So it might be that you're sharing it with other suppliers. It might be that you're sharing it with other public authorities. You might need to share it with professional advisors, for example. So again, there should be a heading that says, who do we share personal data with? And then you just, simple as bullet pointing out all of those different recipients of the personal information. You would normally set out how long that data is kept for. And I'm going to come on to retention in a moment, so I won't go through that in too much detail. And then also what rights the user has. What rights the individual as someone who's provided their information has. And that's things like the right to be forgotten. So the right to have their personal data deleted, which you might have heard of before. Some of you on the call might have heard of subject access requests. So you would a website privacy policy would normally set out what those rights are and how an individual can exercise those rights. That is a legal requirement. Obviously, what you don't want to be doing is absolutely promoting someone to be exercising those rights, because those of you who've gone through it know that it can be a real pain to comply with things like a subject access request. And then a few practical points, which I think are going to be fairly self-explanatory. It needs to be plain, clear language. You know, we draft these types of documents, but when we do draft them, we don't put them in legal jargon. Concise, transparent, including all of the things that we've just talked about. Consider your audience and review and update as and when necessary, or as and when any of those things on the left-hand side change. So it should be reviewed again, I would suggest, on an annual basis. But those things on the left-hand side are the legal requirements that need to go into a privacy notice, or in this case, a website privacy policy. And as I say, that's something that's intended to apply to anyone you collect personal data from. And it's just, you put it on the website for convenience more than anything else, so that you don't need to give individual privacy notices as and when you collect that information. Okay. So let's talk, so that's website privacy policy. Let's talk about data retention policy. So this is all around how long you are storing personal information. So data retention policy is our third sort of in the suite of data protection documents, is a policy document that sets out how long data is all data is retained. So as we'll talk about in a moment, not just personal data, but all data is retained, and how is it disposed of. So when we talk about retention, some of the key things to bear in mind are location, where it's stored, and what the different time periods for different types of personal data are, and what security is applied to that personal data and other data whilst it's retained. When we talk about disposal, we're talking about when's it disposed, how's it disposed, what kind of supervision. And obviously that is going to vary depending on the type of information that we're talking about. So this is a slight lag on the slides. There we go. So as I said, data retention policy really should apply to two categories of data, generally speaking. The first is personal data, so all of the things we've just talked about, names, addresses, email addresses. That's the one that's more heavily regulated under the GDPR, but also it's sensible to have non-personal data in there as well. So any kind of corporate records, any council records that you've got would normally be captured in a data retention policy as well. So let's talk crucially about how long personal data can be retained. So personal data can be held for as long as the organisation needs it for the reason that it was first collected. So I'm often asked this question, but slight lag in the slides, there's no specified timescales for retention. So the GDPR does not say you can only hold certain types of information for a certain period of time. The GDPR, all the GDPR says is you need to hold it, you can only hold it for as long as you need to for the reason that it was first collected. And the reason that I underline the reason it's first collected is because if you start doing something else with it, then the rules change slightly. So you need to think about why did we first collect it, and how long do we actually need it for? Again, there's a slight lag on the slides, so apologies for this. John, are those coming up? Oh, there we go. So in practice, what that means is, and this is sort of the most important takeaway in terms of data retention. In practice, what this means is, it's for the organisation to justify why they need personal data. So that's ultimately what it comes down to. As I say, I'm regularly asked, how long should we be storing certain things for? But ultimately, it comes down to how long do you actually need it? And perhaps will come as no surprise when I say that that is then documented in a data retention policy. Because let's face it, if you have thought about it and you have considered how long you need something, and you have then documented that, it's going to be very, very difficult for the ICO or anyone else to come along and say, oh, actually, we don't agree with that. Because the ICO won't know your organisation as well as you, and there may be specific reasons why you need to keep information for a certain period of time. And to give you an example, employment records is quite a common one. Normally, it seems that there's sort of a general consensus that you need the employment records, obviously, for as long as that person's employed by the organisation, by the council. And the reason for that is that you obviously need to continue paying them, doing performance reviews, all those sorts of things. But also, for 7 years after that person has left employment. And the reason for that is because HMRC can go back 6 years plus the existing financial year. And therefore, you may well need that person's information in order to deal with any kind of audit or accounting issues. You might need it for legal compliance because employees can still bring a claim up to 6 years after they've left. So normally that's where it's kind of left. But ultimately, if you say there is a reason we need to keep it for longer, and you document that and you've properly thought about it, then it may well be that that falls within the principles of the GDPR. So the importance of a data retention policy is that it sets out, and it should have a schedule at the back that sets out how long each category of data is held for. And when I talk about different categories of data, I'm talking about things like employee data. It might be candidate data, people have applied for a job with the council. It might be resident data. It might be supplier data, because even though suppliers are generally likely to be companies, and the individuals at those suppliers, it's still personal data. It could be information that you collect through the website. It could be a whole range of different things. You just need to sit down and agree a retention period on that front. That therefore enables you to comply with the data protection principles that I've been talking about. It also links back to the website privacy policy, because the website privacy policy should set out how long data is retained. So this will dovetail into that. Often the website privacy policy won't actually specify and provide full retention schedules. I did a quick Google before I came into this call, and I know that a number of councils do publish out those retention schedules, but it's not strictly needed under GDPR. It also helps compliance with other kind of regulatory requirements. So there may be other laws, non-data protection law, that requires you to hold records for a certain period of time, and it's efficiency and good practice. In terms of those principles that it helps compliance with, data minimization, in ensuring that you're reducing the amount of data that you hold, storage limitation, which is this point around not holding information longer than you need to, and most importantly, ensuring quality of data. And to give you a practical example of this, and something that I've been dealing with very recently, I've been dealing with a big cyber attack for one of my commercial clients, and they have suffered a ransomware attack. So hackers, I'm pretty sure that they're sort of 15-year-olds in North Korea somewhere. But those hackers had got into my client's servers. They stole everything and then deleted everything. And as a result, clearly there was potentially some big data protection issues. The issue that my client had, and I hadn't advised them on this, is that they had stored everything from when they first set up as a company, which was about 30 years ago. They had never gone through, they had never applied any kind of retention policy. As a result, we clearly had to notify the ICO, but as a result, the ICO were very, very interested and had suggested that there could be quite a hefty fine coming their way. Now, whether through luck, I would like to think savvy legal advice, but whatever it might be, they have managed to get away with an ICO fine. But the reason that they were in that discussion to start with is because they hadn't properly applied this principle of what is our retention policy, how long are we going to keep categories of information, and it was the ICO considered a flagrant breach of GDPR. So ultimately, it's a question of the more you hold, the greater risk there potentially is in the event that something went wrong. So I would suggest that this is something that needs to be considered quite seriously. And if you have a retention policy that you follow, it doesn't need to be hugely onerous, but it shows that you've considered some of these key things. So just very briefly in terms of key terms, we'll clearly have sort of scope, policy objectives, those sorts of things. We'll also have concept of who's responsible, whose overall responsibility is this document, what's the employee roles. I've talked about data protection officer momentarily, but you would want the details of the DPO, or if you don't need the DPO, the data compliance manager. So we then set out the different types of personal and non-personal data. Just a quick note on what called special categories of personal data. So those are things like health records, information about someone's ethnicity or their sexuality or their political views. Those are heightened categories of personal data. And therefore, you need to make sure that the retention periods for that data is less, because it's unlikely you're going to need to hold that information for as long as, say, someone's name, their job title, their employment history, those sorts of things. So that's something to bear in mind. Clearly, it's going to actually set out the retention period for each category. One thing we haven't talked about is in terms of how personal data is disposed of. Is it just deleted from your online systems? Are hard copies shredded? If so, do you use a third-party contractor? Is that something you do yourself? So those should go into a data retention policy, but I suspect in this case it'll be sort of pretty straightforward in terms of just deleting them from your systems. And then reporting, if there's a breach of the policy, or if anyone has any questions, who should they go to? And again, that's probably the DPO or data compliance manager. Okay, so that sort of brings us to the end of the data protection section, which you may or may not be pleased about, as it's still, even sort of 5 years after the GDPR's come into force, still remains quite a complex area of law. But as I say, if you can aim to get those 3 policies in place, along the sorts of lines that I've just talked about, that gives you an awful lot of firepower in the event that anything went wrong. So I'm going to briefly talk about website terms and then hiring agreements, which are sort of 2 more commercial documents. So
just 1 second, Alex. Sorry, Alex. Yeah, we'll do the website terms and conditions. Then we'll go into a bit of Q&A, and then we'll do the hiring terms for people who have community spaces and meetings after the Q&A, just so that we can get the Q&A done before 12 o'clock, if that's okay.
Yeah, that's absolutely fine. Yeah, absolutely fine. Great. So, so very briefly then, so website terms and conditions set out the legal rights, essentially creates a contract between the organisations and the users of the website. This is probably one that people might be thinking, well, do I really need this? To give you a brief practical example, you might have seen in the news recently that the National Lottery had to rely very heavily on their website terms and conditions. An individual was playing, I think what's called their instant win offering, and they had won. Their predetermined ticket outcome was £10, but because of a software glitch, it showed 2 numbers. It showed £10 and £1 million. And this person, whether or not they genuinely thought they had won £1 million, or whether or not they were sort of trying a bit of a fast one, brought a claim in the High Court, so quite a serious claim, that actually the correct amount they had won was £1 million. Whether or not we can blame them, I don't know, but there we go. The High Court said that no, that's not the case, and the reason that it wasn't the case is because Camelot, who did run the National Lottery, were able to rely on their website terms and conditions to say that actually their website terms and conditions had provided for software glitches in the event that the image isn't to be relied upon. So briefly then, in terms of what would go into the things to consider, so it sets out the rules and guidance for how users can use your website. It creates a contractual relationship between the parties. It sets out terms of use. It sets out intellectual property rights. who owns those intellectual property rights and how are they protected and what others can do with them. There are disclaimers on there, which are going to be very important to make sure that, that individuals aren't relying on the information on your website, and it's going to set out the governing law as well. So, the importance of these, as I talked about before, they are a document that are often relied upon. They act as a binding contract. You'd have a contract with someone who's using your website anyway, as perhaps bizarre as it sounds. These set out the terms of that website, in particular, the legal rights and obligations that apply to the parties. The most important thing from your perspective is limitation of liability, to make sure that, for example, you're not guaranteeing any kind of uptime of your website. If there are any glitches, that you're not liable for it, that you're not giving any financial advice or anything like that, and set the governing law which is relevant if someone's using it from overseas, which I suspect they shouldn't be. So the key terms, you normally have a section that said users accept the terms and conditions, and if they don't accept them, they can't continue to use your website. Intellectual property is going to be really important, making sure that all the copyright and trademarks and any other imagery on your website is yours and that they can't use it, and that setting out how and when the individuals can link to your website. It sets out obligations, what users can and cannot do, and obviously depending on the functionality of your website, that's going to change depending on the complexity. So, for example, if you can pay through your website, or if you can review documents through your website, then clearly those obligations are going to need to be more bulky, more expanded. If, for example, users can actually submit information to the website, or even if there's forums on there, then we want to regulate quite closely what they can and can't do. They can't be discriminatory, etc. Limitation of liability, as I say, you want to disclaim your liability in as many cases as possible, and set out what the governing law is, and make sure that those terms are properly incorporated into your website. And what that means in practice is having a link at the bottom of the website to make sure that users can click on it if they want to, which is probably going to be unlikely in most cases, but gives you the protection. For me, this one is a real no-brainer, because no organisation should be liable for actions through their website. So having a set of what don't need to be really detailed terms, but just a basic set of website terms can really protect you. And I think that Camelot example gives a good flavour of that. So I think with that, John, I'll pass back to you. I've gone on slightly longer than perhaps I was anticipating. If you want to go over to the Q&A. Yeah,
no worries. If you want to unshare your screen for now, and then we'll go into Q&A. And then anyone who wants to know about hiring, if you're hiring out venues or facilities, we'll do that afterwards. So yeah, briefly to you. So a lot of people are asking about templates. So first question is, and I see people on the chat are sharing their templates, saying go and grab mine. What's your general advice for these kind of documents, just grabbing someone else's doc and then just doing a search and replace on their council name?
Yeah, I think, as you know, John, you and I have worked together for many years. I'd like to think I'm a pretty pragmatic lawyer, and I fully expect that, I fully appreciate that that's the obvious thing to do. And paying a lawyer to prepare these things probably isn't an optimal solution. That said, it's something that I've seen go wrong a lot of times. And what I always say to any clients, regardless of sector, regardless of whether they're public sector or not, is if you take someone else's documents and something goes wrong, and there is a claim or complaint, whoever is adjudicating that claim or complaint is going to take probably a fairly dim view of the fact that you've essentially just sort of taken a document from elsewhere. And obviously the cost of rectifying these things later on is going to be far more prohibitive than the cost of sort of getting it in place in the first place. But that said, it's something that I know happens, and I suspect in 90% of cases it never causes an issue. So it's not something I would recommend, but I can understand why organisations would do it.
Yeah, I can see some people, they're a hosting provider, the website provider provides terms and conditions, but again, that probably applies there, because each kind of each parish and town council are slightly different in terms of kind of their setup. I mean, if a town and parish council was, you didn't know, came to you and asked you to produce these documents, how much does it typically cost?
That's a very good question. It's really ballpark figures for are you talking about that for that suite of documents?
Yeah, all those docs you talked about.
Probably for those suites of documents, it's just someone normal client just came to me and asked for those, probably somewhere in the region of sort of £800 to £1,000 plus VAT, something along those lines.
Okay, cool. And if if we could, I mean, I haven't mentioned this to you, but like maybe if we did some kind of partnership deal and we were able to get lots of customers, would you do a discount? Like if we had lots of customers who'd be, or anyone on the webinar would be interested?
Yeah, absolutely. Certainly, you're throwing a few curveballs at me today, John, and I'm keeping me on my toes.
I'm always looking for a deal.
First, the question about tell all of these people on the Scribe seminar about something you've never told anyone else before, including my wife. And now this, but no, you're absolutely, no, it's a really good point. Absolutely. I fully appreciate, I do a lot of work in sort of the parish and town council section. I recognise a few faces on the grid at the moment who I've acted for. So yeah, I fully appreciate that the budgets are tight and we would absolutely do something like that, yes.
Cool. If you want us to explore that further and you're interested in getting these documents drawn up for you, just type a yes into the chat right now and we'll gather a list of all, and maybe put your email. Well, you don't have to share your email, we'll find it. Just put a yes into the chat and we'll follow up with you to see if we can see how many people get responded to, and then see what kind of deal we could get to get all these documents produced specifically for you to make sure you got the legal armor in place. So I'm just going to ask the questions while people are just responding on that. I'm going to ask questions on behalf of people. The first question was around sharing your data protection policy outside the organization. People have put it on their website. It's not an internal document. So is that a problem?
It's not really a problem. I think problem is probably too strong a word, and you're not in breach of some kind of law. I normally recommend that clients don't, because one, I think it confuses with the website privacy policy. And you touched upon it briefly there, John. The website provider, you're absolutely right, website provider will provide you with a standard document, and obviously that may be absolutely fine. But because I think a website privacy policy really should try and cover all of your different types of privacy notices, it's very unlikely, I would have thought, that a software developer knows the business well enough to have kind of captured all of that. I admittedly could be wrong about that. So it's not a massive issue. They're not wrong as such. It's not something I normally advise, because I think if you put your data protection policy on the website, you sort of let people into the, having a look under the hood of the organisation, and that normally, from my experience, when you've got someone who's got a gripe, and I'm sure those on the call have had, difficult people in the past to deal with, who sometimes use data protection as kind of a hook in. And I think sometimes putting a data protection policy on the website can kind of enhance that and amplify that. So I would normally put the website privacy policy on there, because that's what you need to do.
Cool. I'm going to ask one more question. We've had a whole bunch of yeses, probably 20 or 30 yeses interested in getting these documents produced for their local councils. So that's really good to hear. Continue adding your yeses if you're interested in getting it Leathes Prior to produce these docs for you. I had a question, good one from Sally, saying, if there's no interaction on, this will be the last question, and there's some more in there, and we'll see if Alex can answer them afterwards in an email. If there's no interaction on the website, no comments, no forms, just information only, do you need website terms and conditions?
Yes, because it's likely that some kind of analytical data, IP addresses, are still being collected in the background. Clearly, the website privacy policy is it's going to be much lighter. But as I said, I just want to make this point again, because it's an important one. The website privacy policy, because you need to provide privacy notice to everyone that you collect information from, whether it's regardless of through the website or not. Normally, what I advise clients is put the website put all of those privacy notices together in a document and then put it on your website. So you're not limiting that website privacy policy to only people who interact with you through the website. You don't have to do it that way. I just think it's the easiest, the cheapest, the most streamlined way of doing it. So, for example, you might have, as I say, people who apply for a job with the organisation. It might be residents who provide their information to you. You can capture all of that in one document, so you don't, and you can just, and then if anyone ever has any questions, you just say, look at the privacy policy on the website. That would be my view. But if you want to limit it only to website users, which is probably what you get from your software developer, and you don't have individuals interacting or providing information through it, then yes, it's going to be, you still need one, but it's going to be a much, much lighter touch document.
Cool. Okay. So we got, Alex can go 8 minutes longer to 10 past, he said. So we've got 8 minutes left. I'm going to hand back to you, Alex, to cover hiring terms.
Excellent.
Thank you. Cheers.
Thank you, John. My Norfolk internet has obviously decided that it's going to be slowing down a little bit, so apologies.
I can share for your behalf.
No, that's all right. That's all right. It's about 5 seconds behind, but there we go. Hopefully you can see that now, John. Okay.
Yes.
Great. So thanks everyone for sticking with it. I did say at the start, this is quite a dense topic. This is really practical stuff, but there's a lot to get through there. I wanted to try and give sort of as much kind of value to the people on this call as possible, so that if you want to go away and sort of do some of these documents yourself or tweak things, then you've got some ammunition to do so. The last document, it's probably best that we've left it to the end, and some might have dropped off, because this might be the document that not everyone needs. It's possible. There are no, this is just a question of fact. If you're hiring out community spaces, meeting rooms, halls, community halls, those sorts of things, then this is a document that I'm going to strongly suggest you need. However, if you're not, then clearly you wouldn't need this document. So it's probably not going to apply to all councils across the board. And again, my internet's decided to lag slightly. John, I wonder if it might be easier if you share slides.
There you go, done. Yep.
Yep, brilliant, thank you. So hiring agreements, as I say, this is to cover things like meeting rooms, community halls, classes, events, potential repeat bookings. And the point here is to make this process as easy and as streamlined as possible. So hiring agreement is going to be an agreement between the council and the person who is hiring. I've just seen a comment pop up. I haven't been sort of responding to comments. I think that's an extremely good point from Mandy Ship. So thank you for that. I had a look at, I Googled Parish Council hiring agreements, and some of the documents are insanely long. And I deal with corporate transactional work where you've got sort of 100-page SPAs, and some of the hire agreements weren't actually far off that. It was ridiculous. So Mandy, that's a really, really good point. And I think hiring agreements is about having a short form document that is set out in a nice, easy, clear to understand way that isn't going to spook people, because people don't want pages and pages and pages of legal documentation. Often you might be dealing with individuals who are on a birthday party, or want to run a Zumba class or whatever it might be. So this is a document that I would suggest is structured as follows. You have a one-pager, which is your what we call your hire details. That sets out all of the variables and all of the things that are going to change on a case-by-case basis. I'll talk a bit more about that in a second. You then attach to that one-pager, you have a short set of sort of standard terms and conditions. And those standard terms and conditions will not change at all. They will just remain exactly as they will apply for all of your different kind of hiring activities. And the point of that, I call it efficiency or uniformity. It's to make sure that you've got a nice, easy to implement document that you can just roll out, but also you know that when you're hiring out space, you're doing it on uniform terms, and that you're not getting different members of council staff signing up to different things, which is clearly going to impact on your legal position. And the reality is that with a hiring agreement, this is probably one of the higher risk areas, because if someone damages it, damages the property, if they suffer risk on the property, if there's a loss of, I don't know, loss of personal items, this is all the stuff that a hiring agreement is going to cover off against. So if you have just one document that is short, is sweet, but covers the key things. So John, you can go to the next slide, please. Yeah, so the importance of this document, I think, kind of speaks for itself, really. This is creating what for a parish council might be one of its more sort of serious legal relationships. It's obviously a way to generate income and fees. It's it gives councils flexibility in terms of what they can do with that space. It creates a legal relationship with the individual who's hiring. And if you don't have an agreement with someone who is hiring space from you, then the reality is the terms that apply to that agreement are going to be very, very grey, very ambiguous, and that the person who's hiring can probably argue to their advantage for a reason that I'll come on to in a moment. So it creates that contractual relationship. It sets out the important obligations that will apply to someone hiring that space. So these are clearly things like, what behaviour is expected of them when they're hiring. Things like practical points. When's the booking apply? What's the hire period? To make sure there's no ambiguity around that. It will set out what that individual needs to do if they need to. If, for example, they need to make good any potential loss that they've suffered. So it sets out those clear obligations in a nice, easy to understand way. Liability, probably the most important aspect of the hire agreement, because you really want to limit your liability as much as possible. Someone is injured on site, nothing to do with the council. You want to make it clear that that is not your liability, but that's the liability of the person who's responsible for the space at the time. And also it gives you a right of recourse. If someone goes in and trashes the place, you've got that comfort, you've got that ability to be able to either bring a claim, probably less likely given some of the budgets that we might be talking about, but it gives you that kind of, again, it's all about having that ammunition, about having that armour in the event that things go wrong. John, if you just go to the next slide, please. So, key terms, what actually needs to go into this document? So, as I say, you have it in two parts: the hire agreement, which sets up the contract variables, and then this sort of the agreed standard terms. So, hire details, clearly the name and address of the individual or the organisation that's hiring it, the event, the date, the hire period, the venue, all of that sort of stuff. You might here want to, if, for example, if you have some permitted numbers, you might want to have a set permitted numbers within that, because that might vary depending on how you hire out any community space, and obviously what the charges are and what the deposit is. Let's get that stuff nice and clear, easy to understand, in a digestible way. And also, importantly, because I appreciate, and I've talked about this on a number of different occasions, I know that clerks of parish and town councils, you have to kind of be experts in everything to a certain extent. I know that you've got a lot of juggling to do. So let's make this process as easy as possible. Let's not have to go into a Word document and hack about with it. Have a front page that you can print off. You have copies there, and you can just fill in as and when necessary. In terms of ease, let's then have these standard terms in place. So that would just attach to the back. The two documents together would form the contract, and that would set out things like the use of the venue, behavioural standards, what you're expecting of someone. It would set out payment, when payments would be made, when's the deposit to be made, all of those sorts of things. Liability, as I talked about, that's going to be a really, really important one. We want to make it absolutely clear that individuals are on the premises at their own risk. And unless it's something the council have done, as perhaps the building owner. If the building wasn't in safe condition, but otherwise we want to make it clear that we are not liable for anything that happens at that event. You might want to stipulate information regarding, substances, alcohol, drugs. You might want to stipulate information about noise. All of those sorts of things would go in there as well. What the cancellation terms? When can an individual cancel? Is there a cancellation fee, for example, if they cancel within a certain period of time? That's normally one of the things that's argued about the most. I think it's important to get that in nice and clear. And then you'll have various other sort of general things, like, for example, what happens if, let's all hope this never happens, but you're COVID Mark 2 or Mark 3 or Mark 4, whatever iteration we're on, and you can't open the venue. Terms that would cover that to make sure that the council's not on the hook in the event that you're prevented from doing so. So that's a real whistle-stop tour. I think those documents, I'm a big believer that keep those as easy and as streamlined to understand, but make sure that you're covering some of those key points, and that will make sure that you have the legal armour that you need to make sure that you're prevented from a complaint or claim. And then, John, just final thoughts. I mean, this has been a real sort of whistle-stop tour over those 5 documents. Obviously, coming at them from slightly different angles, and they apply in slightly different situations. But for me, this is quite low-hanging fruit. This is something that you can probably implement quite easily. It doesn't need to cost an arm and a leg. This isn't something that, without wanting to do myself out of a job, I'm suggesting you sort of run off and you pay private lawyers to go and prepare sort of hundreds of pages of documentation. But this is low-hanging fruit, and I would strongly recommend that you implement all of these documents in your organisation moving forwards.
Excellent. Thank you very much, Alex. So we're not going to go into Q&A now because we're running out of time, but let's just turn on your cameras and wave and clap let's show some appreciation to Alex for giving a really good talk. Thank you very much, sir. I wish everyone have a really good day. We'll post everything out to you with the slides and the recordings. Otherwise, yeah, have a good weekend. See you all next time. Bye-bye.
Thanks all.
Thanks, everyone.